Hello, everyone, and welcome to the webinar on the future development of international law. This webinar is hosted jointly by the National University of Judicial Sciences, India, and the Canadian Institute for International Law Expertise, Cifile. It's a great pleasure to see you all here in this webinar. I would like to thank Dr. Chakrabarty, the Vice Chancellor of the National University of Judicial Sciences, India, and Professor Sreenivasulu, Distinguished Professor of Law, National University of Judicial Sciences, and Madame Christina Kojic, Scientific Member of the Canadian Institute for International Law Expertise, Cifile, for accepting to be part of this webinar as a speaker. On behalf of the Canadian Institute for International Law Expertise, I would like to welcome you all today, as well as Cifile's members, lawyers around the world, and other distinguished participants in this webinar. At this historical moment of international relations affected by the Ukraine situation and COVID-19, I will share with you some new challenges facing the development of international law. In fact, thinking and rethinking about past, present, and future of international law will help us to define new role of international law in the international community. International law is a law of international community, and international community is based on international relations. So international law is a law of international relations. In the past years, in the emergence of new challenges, such as climate change, environmental degradations, territorial conflicts, terrorism and eco-terrorism, and COVID-19 pandemic, have created and is still creating health issues, economic challenges, political crisis, and social conflict around the world. These challenges and conflicts requires international community to re-evaluate global governance and international structures which are based on Second World War and post-World War. So now we are facing a new era of international community, which will not be similar to the past. In the same way, we are observing in many countries, including Ukraine, populism, extremist ideology, nationalism, human rights violations, and honorism in the international community. One of the significant challenges facing international law in the normative challenges. And you know, the Charter of the United Nations of 1945 and the Statute of International Court of Justice have defined the established current international law. So it means new efforts to systematically codify, modify, and develop international law according to these new challenges. The second major challenge facing international law is a structural and institutional challenge. As you know, most international organizations, including UN and Security Council, are created after World War II. They're supposed to establish international community based on principles such as equality between states, self-determination of nations, international corporations, respect of human rights, and peaceful conflict resolution. But we can see today, these principles are transforming to unilateralism approaches in international relations, which will lead to geopolitical tension and threat of global peace and security. In this concept, it's clear that the current structure of international organizations, including the UN, cannot keep its promises to establish international peace and security, solving territorial conflict, protecting human rights and environment, and eliminating poverty in the world. It is clear that dealing with global challenges require global participation. and corporation. The current world raises interest of the debate regarding reform of the functioning of international institutions such as United Nations, more specifically Security Council. The current composition of the Security Council is no longer reflect international societies. The right to veto and the composition of a permanent member of require a solution in the functioning of international organization for protect peace and security in the world. Another challenge facing international law is a lack of the means to prevent or stop threat to peace and security. Here, the question is the current situation of international law could prevent or even stop threat to international law and security. Surely, the current state of international law is unable to do this function. In addition, the United Nations, including Security Council, had limited authority in this global crisis. Another challenge is economic confrontations between states. International societies is confronted with economic crisis. It reveals a specific weakness in global economic order and financial system in the world. The current world economy, based on free market, is changing in uncertain situations that increase competition between state and international actors. Confrontation and playing an increasing role in international relations between countries. The multiplication, unilateral action, extension to the field of high and new technology, economic sanctions, disagreement on international organizations could be only some example of economic confrontation in the future of international law. You know that international law as a body of law that governs relations between the states and international organizations and private persons in global framework, exposing its weakness in current situations. Besides, the conflict between national sovereignties and global values of international community, such as environmental protection, sustainable development, and human rights, are unresolved. In addition to international justice system, including International Criminal Court, International Court of Justice, seems confronted with several limitations in their functional and practical aspect. There are other challenges and weaknesses in the future development of international law, which remains for further research and discussion. In conclusion, I could mention briefly some solutions for development of international law. Number one, international cooperation and multilateralism are essential to maintain peace and security in sustainable development and human rights in this ongoing situation. The commitment, peaceful settlement of international law in the fundamental principle of the Charter of the UN, and however, the existing world order is changing. Based on this projection, can we predict a new global challenges with transform world into new global order? Number two, encouraging sustainable development. Promoting and encouraging sustainable development could help the world to combat global challenges such as climate change, poverty, and other challenges. Number three, strengthening international justice system. A strengthening international justice system could hold accountable those responsible to international crime such as genocide as crime against humanity. Number four, recognize public participation in global matters. Public participation and public involvement in international law could help codification, implementation of international law in national system. Finally, reforming United Nations and Security Council. UN should show its adaptation for new reform based on the democratization of international institutions. Such democratization help to empower the decision-making process and improve in transparency in these situations. So the issue here is whether we can imagine that resolving United Nations and establishing a new organization in the future. Thank you for listening my presentation. Now, I would like to invite Dr. Chakrabarty, the Vice Chancellor of the National University of Judicial Sciences, to deliver his speech on the development of international law.
President, the Vice Chancellor is currently not logged in.
Okay, okay.
So he might join a little later.
Okay, okay. We can listen your, you can deliver your speech before him if you want.
Yes. Okay. Thank you, President. Very good morning to Canadian friends. Very good afternoon to my European friends, including Christina. And very good evening to all my Indian friends. Indeed, this webinar is being organized by the Canadian Institute for International Expertise and National University of Juridical Sciences, Kolkata, at a moment where the entire world is trying to find a solution to one of the greatest problems that 21st century is actually looking for. That includes COVID pandemic, and as well, more than that now, Russia and Ukraine war situation. Two extreme situations, two exigencies, which have once again thrown open the great debate with respect to the international law and its implications. We have been studying, reading, and also experiencing that number of times we have seen scholars arguing that international law is perhaps a toothless tiger. Of course, not as a scholar of international law, but as a common man, I would also like to endorse that statement, because every time it is happening that though we have international law in place, it is unable to find solutions to number of problems, right? It could be during Gulf war situation and also now Russia and Ukraine war situation. I'm saying this because number of nations have imposed sanctions on Russia, including the so-called Big Brother, USA, right? NATO countries are having their own issues and sanctions imposed against Russia. International Court of Justice is investigating against Russia, in particular, the strongman Putin. International Criminal Court is also prosecuting him, right? On all these prosecutions, inquiries, investigations are actually happening on paper in the absence of the party, that is the Russian counterpart. So it gives rise to one fundamental question. What is the importance of international law? Whether international law is really toothless tiger, it is only there for academic deliberations and debates. Can't we invoke international law? Can't we enforce international law? Right? In the most civilized times that we are actually living in now, the 21st century, still we are able to see certain barbaric situations, conditions where certain strong groups are able to show their strength around on weak groups. Certain stronger nations are able to bull around the weaker nations, like it is happening in the current context. So that gives rise to this fundamental question. We have international organizations. We have international law that talks about sovereign rights of each and every country. That talks about civilized society, right? That actually considers one and all to be equal human beings, right? Where all these philosophies, ideologies, fundamental principles have gone, right? Somebody or some nation which are strong, they need not believe, follow all these things. We have seen not only in the current situation, number of international treaties, number of international pacts. The strong nations are not a party. Convention on Biological Diversity, USA is not a party. Climate change debates, USA is not a party. Now, Russia is doing something. It is trying to invade into Ukraine, and it may also give encouragement to certain other countries like China. Tomorrow it may try to invade into Taiwan, Hong Kong, and all, right? So and USA may try to do the same thing with Mexico, right? And even Canada is also just beside USA, right? So it gives a sort of encouragement to other stronger nations to bully around. Already, all international organizations, in one way or the other, are actually bullied by these strong nations. When Security Council intended to adopt a memorandum or a resolution, Russia happened to veto it. Right, all the five permanent members of the Security Council, as per the existing parameters of international law, right? U.S., France, UK, China, and Russia. They have been given veto power. So 4:1. Four countries are against the Russian invasion on Ukraine, but Russia on its own taking judgment for itself could veto it. So what is happening now? The Security Council of the United Nations is unable to do anything. International Court of Justice is unable to do anything. International Criminal Court is unable to do anything. But it is adding to the growth of jurisprudence in the context of international law, right? I'm particularly trying to assess the current situation from international law parameters, right? The charter of your International Criminal Court or International Court of Justice, right? All these charters have actually given power to these international courts to look into any matter where two different nations are parties, or two different nations are subjects. But still, whether the international society has not given them the kind of power they would have required to interfere in this kind of situation, or the so-called strong nations are not really willing to follow the decrees, resolutions of these international agencies, including your Security Council of United Nations, International Criminal Court, or International Court of Justice. Or you are not in a position to execute, implement, enforce these international treaties. ICJ is unable to enforce. In fact, one of the judges among the 15 judges of ICJ, there is one Indian judge, Justice Dalbir Bandari. Reportedly, he has also voted against Russia. And historically, Russia happened to be a good friend of India. But I don't second what they are doing. You may be my good friend, but dear friend, what you are doing is not upright with Ukraine or with anybody for that matter. You have to respect some other nations' sovereign rights. And international law talks about it. You have to treat other individual as equal human being like you. You are part of this civilized society, right? So you being a party to the various pacts, deeds, conventions, and agreements of international law, if you are not respecting what you have actually accepted, what you actually proposed, right, during the times of First World War, Second World War, right, number of nations, including Russia, seconded, rather taken initiation for the formation of United Nations, ICJ, ICC, and number of such civilized nations, protocols, agreements, and all that. But now, when it comes to their own game, they are not ready to follow it, right? So it gives an impression that law is meant for preaching, not for following, right? Or our international law is there only to be followed by developing nations, poor nations, the so-called developed nations, rich nations. They don't bother about international law because they make international law. They fund all these international organizations, right? At any point of time, Russia can stop its funding to United Nations, right? So since you are actually funding these international organizations, and since you are rich, so you don't mind violating human rights. So you don't mind violating sovereign rights of other countries, right? So you are actually owing the world. You are the boss of all the 222 countries or 224 countries, whatever we have. Is that possible as per the civilized nations philosophy? Is that what international law talks about, right? I'm trying to be a little open and bold here because we are living in a civilized society, and there is no time for war, because whatever time we have is not enough to achieve peace. It is not enough to live peaceful life. Such being the case, where is the time for all of us to wage a war? And because of war, now across the globe, its impact is being felt, right? Prices have gone up, markets are falling, fears are, mounting, and now, as I mentioned, it is giving signal to some other strong nations to replicate what is happening now with, Russia, what Russia is doing, right? And weaker nations, right, will be on the receiving end like Ukraine, but the kind of withstanding capacity that Ukraine is showing, the kind of strength, stamina, rather hope, courage with which they are trying to give it back, rather sustain. And the way they are approaching various international bodies, right? They have approached not only Security Council, they have approached NATO to declare, the air and space around Ukraine to be, no flying zone. Of course, not succeeded. They approached a number of other, international legal bodies, but not much to their help. But still, this rise to the debate on the impact of international law. That's why I really appreciate the President, Dr. Abbas Poorhashemi, who has chosen this topic, who has suggested this topic for today's discussion, because it is the contemporary topic, and we all who are working in the field of international law, the so-called international scholars that we should throw some light on this aspect and try to strengthen in what way we can actually execute international law, in what way we can actually influence these nations which are actually having that expansive mood, right? When you are able to yourself be rich and stronger, you are thinking in terms of expanding your horizons by entering into war situations or waging a war, and by violating number of international treaties, agreements, and reducing the other party to a slave, right? When you are trying to conquer something, that means you are reducing the other party to a slave. That's barbaric, right? The first fundamental violation that takes place whenever you think in terms of waging a war against somebody is that you are not treating those fellow human beings as human beings. Violation of human rights law. And you are not respecting that other nation's sovereign rights. So violation of another law, war, and then you are waging a war, killing number of civilians, women, children, everybody. So war crimes, number of things are happening. In fact, it's a genocide. I'm told that Russia has been a party to that convention which prohibits the genocide. But now the way you are sending missiles and bombing around 2-3 top cities of Ukraine, killing civilians, bombing on hospitals, schools, right? It is nothing but genocide, right? It's not a clear war, right? If at all you would like to wage a war, choose a field, right? Or air base, navy base, or open army, right? Go for that kind of war, right? Where you have a like a people, the sportsmen go to cricket ground or soccer ground, or whatever. Like they choose a place and they go and they fight against each other in the most civilian way. In the similar way, either you go for waging a war if you would like to really venture into it. It's not right. You bombing on civilians, schools, hospitals, and all that. So in any stretch of imagination, what is happening now is nothing but a violation of international law. And once again, the debate with respect to the effect, influence, or relevance rather of international law in the given situation, because international law is unable to stop what is happening currently with Russia and Ukraine. International law is unable to stop this genocide. It is unable to influence Russia. It is unable to protect civilians in Ukraine, right? International diplomacy, international relations, international peace is being sabotaged now with what is happening between Russia and Ukraine. When the big brother USA itself is unable to do anything in this scenario, in this context, right? Other nations, what kind of contribution they can make, apart from trying to debate certain things and and analyze the current situation. So in this background, I really would like to invite the international scholars to not just debate, but try to come out with some solution, right? In what way, beyond imposing sanctions, beyond imposing economic sanctions, beyond simply banning airbase or restricting their flights and all, in whatever way that's called positive sanctions, right? In what way you can interfere and stop Russia. Of course, I don't encourage or second that other people should get together and wage a war against Russia. Of course, that's not a solution. That would be an aggregation of the current situation that is already prevailing, not only between Ukraine and Russia, but the entire world is being affected with this. So it gives rise to, as I said, the real question: what is the relevance of international law? We have the text of international law, and what is the impact of that text in the given context of Ukraine and Russia war times? So, such being the case, it's indeed a great privilege and a pleasure to be part of this debate and discussion organized by two institutions from Canada and India regarding future development of international law. I would really happy if future development of international law would be rather in a position to stop this kind of genocides, would be in a position to treat all nations equally, would be in a position to protect human rights, stop genocides, and treat one and all equally, and try to go for renaissance that we are all have the equal right to live, equal right to be part of whatever society group that we are in, and we have equal right to get respect from everyone around, irrespective of our economic, social, political background, irrespective of the fact whether we are a small nation or a big nation, rich nation or poor nation. We are all human beings. We are all civilians. And that civility, humility, if we are able to imbibe among one and all, irrespective of our strength and weaknesses, that kind of euphoria, that kind of philosophy, if we are able to perceive in not only in the text of international law, but its implementation, its effect in any given context of international violations of international peace, tranquility, and international diplomacy. So these are my few thoughts, and I'm thankful to Canadian Institute for International Law Expertise and as well National University of Juridical Sciences, Kolkata, for giving me this option, for arranging this platform to share a few of my thoughts. Thank you.
Thank you so much, Professor, for your kind and excellent presentation for the future development of international law. Now I am inviting Madam Christina Gajic, a scientific member of the Canadian Institute for International Law Expertise, Cifile, to deliver her speech on the development of international law on the European perception and concept from the Europe. Thank you so much.
Good day and good evening to everyone, and thank you for the invitation to this webinar. I will tell something about new development of European law, but as we know, related to the international law, European law is very, very wide, so I choose a few examples of recent changes which are very important and will affect to international law too. First, I want to say that the treaty on the functioning of the European Union is one document which is the most important for all member states and all acting in all fields of life of European Union and their citizens. So it sets two relation of European Union to international law and internationally in general, and it promotes democracy, rule of law, human rights and fundamental freedoms, etc. I know that I have only 10 minutes, so I will try to make shorter. But as I said, European law is very, very wide. So the rule of law is one of the founding values of European Union, and it, in terms of development and cooperation, it's transmit into the following efforts. So that is a promotion of human rights and fundamental freedoms. What is always important for the citizens of the EU, and related to the international law. because it is based also on United Nations Declaration, because all member states of the European Union are members of the United Nations. So that is Declaration on Human Rights, United Nations Declaration, that is very important document too. And through the treaty, the member states take obligation to accept all, and through the declaration of ratifying Declaration of on Human Rights, Universal Declaration. Then promoting the governance and accountability is important. Then modernize of the justice system, that is very important. That is why I choose to talk about it more in this webinar, because digitalization is very important of the justice system, and the COVID-19 pandemic spreads the digitalization of justice in the EU, as it affects on all parts of our lives internationally, all around the world. Digitalization of justice is important because now we in Croatia have online hearings, because we have two small courtrooms, and it isn't possible to make a distance of measures of COVID-19. So it has been held through the online, but across border that is more difficult to make in the moment. So that's why the European Union brought new regulations regarding that online hearings cross border, but that isn't possible to do it overnight. It needs, as you can see here, from 2020 starts a proposal for that regulation, and it is still not adopted. But it is very important, this system e-CEDEX, that is e-justice communication via online data exchange, that is exchange data of the documents and other judgments and other judicial documents across border. So now that have to be online. But that system is very difficult to set up in a short time. So this process is still going on, and now will be slower because of the war on Ukraine. Now this is priority, and we can see that we are not secure as our system of EU LISA, and that is European Agency for the Operational Management of Large-Scale IT System, in area of freedom, security, and justice. And they control borders too, and migrations. And now we have refugees from the Ukraine, and now that is the problem. But Union will try to make this process faster. But in this moment, I can see that maybe this regulation and this transfer from the SCODEX system to EU LISA will not go fast, and maybe will not be held in the first half of 2023. And that is very important because of the security and of the borders and migration, as I said, because we have migrations from the east too, and now we have refugees. And European Union member states, we are with Ukraine, of course, politically now in this war, and we are receiving refugees this moment. And as we can see through what's going on in Ukraine, that after invasion stop, they will need to rebuild the country again. So for now, we have receive the refugees for 3 years, and they will implement in our children are going to school already, and people Ukraine refugees are trying to find the job. So they make, in fact, one kind of assimilation now, and maybe will last more than 3 years. So that is about, and now I have to say that because this is a crucial problem in this moment is EU, maybe it's not from this presentation, but it is related to it too. because of these borders and security. And now last week felt one drone Russian here in Zagreb, and that means that we are not secure even here or any other member states close to Russia, or maybe not so close, but member Union, because we are on the side of the Ukraine. So this transfer maybe will be longer, but it is very important for the justice system, for the judgments and cross-border exchange of the documents and other inside the country of European Union. And that will affect, of course, internationally, because people from other countries have some investments here or court procedures here according to the cross-border and exchange, and that will affect internationally, in fact, not only on the members of EU. So that is about digitalization of justice. And now what I think that is very important is Brexit, which affects on EU law and on UK law, in fact. And because after transition period of the Brexit, so when UK left the Union, still we have some things like this directive about VAT, value-added tax, which will have effect on the UK and on the EU legislation for next 5 years for the dispatch, which has been held before the Brexit. And of course here are the judgments of the Court of Justice of European Union, and United Kingdom is a common law country, so which means that they every other judgment can be have to be based on the judgment before. So some of judgments brought Court of Justice of European Union, and now the highest court in UK is Supreme Court, but they will have case law from this Court of European Union, and they must to apply it for the other judgments according to their jurisdiction of as a common law country. So this is very important, and it is important, the free trade agreement between UK and EU, which they finally reached just before the Brexit. And it is important for the goods and services. This free trade agreement is the most important part of the agreement. And for the other, as investments, state aid, and other very important things between and areas between UK and EU. So I already mentioned this directive on a common system of value-added tax, and that is important according of the Article 51 of the withdrawal agreement between UK and EU, and will stay important after 5 years. And this directive was amended many times, as a very important tax system is very important in every country. Also in EU is very important, and it is not possible to reach a single tax system in single VAT for all member states because of different GBP. It is different in every country, so it is different tax, and that is a kind of problem, but we live with that, and it isn't possible to make it unique. And these amendments of this directive, the most, as I said, this directive has many amendments, but it is important this regarding Brexit and leave of the UK of the European Union. That is important because of COVID pandemic and supply chain related to the medical devices and vaccines, which have to be with less tax, of course, or without it, and regard temporary exemptions of importation of certain supplies, of course, related to the COVID-19 pandemic. And very important that every member state, as because of the principles of subsidiarity, have to harmonize their legislation regarding this directive or any other with the legislation of European Union. With this directive or any regulation must be harmonized in some time, which is regulated through the directive on which dates have to be harmonized, that regulation. So, as I said, I can talk about these subjects more, but I know that my limit is only 10 minutes, so now I will stop. And thank you for your attention. And if you have any questions, please let me know. So that is for now. Thank you for your references or my emails. If you have any question, you can write me and ask about it, because we are limited by the time. So I think, and now this problem of Ukraine show up as a very important, and COVID is 2 years already, and some other problems are showing up, and more slowness is I can predict the more slowness in procedures regarding this regulation, as I said. Yeah. Thank you.
Thank you so much. Thank you so much, Christina, for your excellent presentation. Once again, on behalf of the Canadian Institute for International Law Expertise, Cifile, I would like to thank all speakers and participants in this webinar. And as you know, we will, because this was a little private between us for scientific members, and it will be distributed in the social media like YouTube and Facebook and Instagram. Great. It looks like we have covered most of the issue. Thank you, everyone. We appreciate your being here, and thank you for joining us today, and we will see you next time.